Thank you everybody for joining us today. My name is Alyssa Marquederi. I'm the Deputy Director of the Institute for Innovation and Prosecution at John Jay College. I'm very excited to welcome you to this critical and timely conversation on wrongful convictions of women and what we can do about them. Some background information. According to the National Registration of Exonerations, wrongfully convicted women are more likely than their male counterparts to be convicted of crimes against children and of crimes that never even happened. This pattern of criminalization without crime underscores the unique injustices that women face in the criminal justice system. And we are grateful to the registry for their partnership in sharing and interpreting their data. Now it's my pleasure to introduce our incredible panelists. Unfortunately, Prosecutor Tayak will not be able to join us today due to a last-minute scheduling conflict, but we're grateful to have three extraordinary women with us here today. We've got first Valena Beety, who's a professor of law and deputy director of the Academy for Justice at Arizona State University, Sandra Day O'Connor College of Law. She served as the founding director of the West Virginia Innocence Project, as senior attorney at the Mississippi Innocence Project, and began her career as an assistant U.S. attorney in Washington, D.C. Now, one thing that she did not mention in the bio that she sent me is that she is the author of a book, a fantastic book. I recommend it to everybody who's watching to read it, called Manifesting Justice. And so she will hopefully tell us a little bit about that during the panel. We also have Marissa Bluestine, who's the Assistant Director of the Quattrone Center for the Fair Administration of Justice at the University of Pennsylvania Carey Law School. Before that, she was the Executive Director of the Pennsylvania Innocence Project. And last, but certainly not least, we are thrilled to have Sunny Eaton with us, and she's the Director of the Conviction Review Unit at the Nashville District Attorney's Office. And she was previously a criminal defense attorney for more than a decade. As always, all of our audience members are welcome to submit questions in the chat throughout the panel, and we'll try to get to as many of those as we can towards the end. And so without any further ado, let's jump right in. The first question is for Valena. Valena, we're hoping that you could briefly place this issue in context for us. You know, what does the literature say or the research say are the most common causes that contribute to the wrongful convictions of women, and how are women of color and queer people particularly impacted?
Well, thank you, Alyssa, for hosting this and for organizing this. And thank you to my fellow co-panelists for their experience and their expertise that they're bringing to this conversation as well. So thank you to IIP. And I'm going to share my screen because I made a little PowerPoint. So I hope this is helpful in discussing this topic. And I appreciate what Alyssa said about my book. So I do have a book that just came out that is specifically about wrongful convictions of women. So if this is a topic of interest to you, I would love to chat with you further offline, and happy to talk with you about the book as well. It comes from my own experience, both far more briefly as a prosecutor, but then also as an innocence litigator. And that's been my professional experience in my career. So I wrote the book Manifesting Justice to tell these stories of wrongfully convicted women and wrongfully convicted people in the LGBTQ community as well. I didn't see these stories, these narratives being shared, and I fear there may be a cyclical component here of a lack of awareness of women's wrongful convictions leads to more difficulty in tapping into the number of women who are wrongfully convicted in prison right now, and also the particular causes of their wrongful convictions. The storyline for the book is two of my clients, my client and her co-defendant in Mississippi, who were wrongfully convicted due to a confluence of gender bias, of bias based on their identity as lesbians, and based on faulty forensic evidence. And you'll hear me come back to this issue of faulty forensic evidence because it plays a key role in the wrongful convictions of women. This photo is the happy ending when they were released, but they did serve 10 years in prison for a crime that they didn't commit, and moreover for a crime that did not occur, which we'll also come back to that. So this is an issue, the wrongful convictions of women, in part because we've seen such a dramatic increase in the incarceration of women, particularly since 1980. We've seen this dramatic uptick. And even though there are fewer women incarcerated than men, we've also seen that state prison populations for women have grown faster than they have for men, again, since about 1980. So to provide that background context, wrongful convictions of women, and here's some research from Elizabeth Webster and Jody Miller looking at particularly straight white women, but they're largely convicted for domestic crime scenarios. So where they are a caretaker, some domestic role they may have to a child, to a partner, or even to someone elderly. A lot of these are child death cases and go back to these social narratives of mothering and of caretaking. Secondarily, we see that these women are wrongfully convicted for their involvement with a man who committed a crime. And that's a broader pattern across the criminal justice system as well when we look at the incarceration of women for crimes they did commit. So maybe they were driving the car, they were involved in some way, but we also see this with wrongful convictions where there is a man who has committed a crime. So why are women wrongfully convicted? There's a couple of reasons for this, but one of them is false confessions. And this greater likelihood of women to internalize blame, even if there is no wrongdoing. So again, we see this with instances where no crime occurred, but internalizing a sense of responsibility for what may have occurred. Amanda Knox, who was wrongfully convicted in Italy, I think succinctly summarizes one reason why this happens, particularly in an interrogation setting. So she says, women are raised under a different social incentive structure than men, where attitudes of compliance, of deference to authority are more encouraged. And this finds its most damning realization in the interrogation room, a situation designed to amplify the absolute control and authority of investigators, an experience I know only too well. So I'm going to briefly talk about no crime wrongful convictions. Marissa, with her extensive experience, is going to dive more deeply into this. But I just want to put it out here for our discussion this hour. And this is where there is a charge against a defendant and then a conviction, but no crime ever occurred. And women are more likely than men to be convicted where no crime occurred. And I'll just go back a second. So Amy Wilkerson, this is the woman in this picture, and she was and is incarcerated for a child death that she did not cause, that was a natural death. And I have a current client, Tasha Shelby, in Mississippi in Harrison County, who is incarcerated again for a child death that she did not cause, that was a natural death. Professor Jessica Henry, if you're interested in really diving deep on this, has written a book on no crime wrongful convictions more broadly. It's called Smoke But No Fire. Has a number of narratives in there if you're interested in this area. And the data, which again, Marissa's going to go over this, but if we look at the relatively small number of women exonerees, we see that they disproportionately represent no crime wrongful convictions, and that 70% of women exonerees in the National Registry were convicted where no crime actually occurred. So 70% of them in the registry. So what is a solution to this? One solution is more reliable forensic evidence. A lot of these no crime wrongful convictions tie back to faulty forensic evidence or faulty scientific evidence that was presented. And we know so much more now that demonstrates that that evidence was faulty or false. So no crime wrongful convictions often due to faulty forensic evidence. One example currently in the news, and she continues to be incarcerated, but Melissa Lucio on death row in Texas, her conviction has really been challenged as to whether this child death was something that she caused or whether it was a natural falling down the stairs occurrence for this child. Melissa Lucio also there's evidence that she falsely confessed. Now, I don't know tremendously detailed about her case, but I do want to point it out that it has that confluence of an unreliable confession and unreliable forensic evidence. Another example is Frances Choi. Frances Choi was 17 years old when her home caught on fire and her parents both died in the fire. She was charged with arson and with their murder. And her conviction was reversed in 2020. And this is a confluence of faulty forensic evidence. Again, in this case, it was fire science evidence, prosecutorial misconduct, and then race and gender discrimination. And the court, in reversing her conviction, looked at this confluence of errors and that there was a substantial risk of a miscarriage of justice in her case. And I just want to give a quote from her attorney, Sharon Beckman, who runs the Boston College Innocence Project. She says, "It's clear to me that how Frances Choi was wrongly convicted was a combination of racism, race and gender stereotypes, and a complete dehumanization of her. It's clear that an essential ingredient of the wrongful conviction of women is to dehumanize them." So I'm going to end on that note, and we can move on with our discussion. Thanks, everyone.
Thank you. Thank you so much, Valena, for giving us that context and that overview. And I'm sure Marissa and Sunny have a lot to chime in on as well. I guess before I have a list of questions as always, but I always prefer that this be a real dialogue and conversation. So before I ask Marissa her first question, I wanted to give the panelists an opportunity to just respond off the bat. No pressure, but rather than just, again, me going through the questions, trying to facilitate more of a conversation here today.
One thing that I wanted to add to that, and I'll talk more specifically about one of the cases that I worked on in just a little bit, but I find that the question I'm asked most often is why it is so hard to exonerate women, why it takes longer, why it happens less often. And I was having a conversation with someone about this yesterday, and they made an excellent point that I really hadn't put into perspective. I get tons of letters from men in prison. And something that keeps me up at night is how few I get from women in prison. It's a problem that I'm actively working to solve. But I also get a lot of letters from women advocating for men, from their mothers, from their daughters, from their girlfriends, from their wives. I get none for men advocating for women in prison. And one thing that we know, and Valena talked about quite a bit in her book, is how public pressure can really play into exonerations. It can really push these cases forward. It can make other people look at them. But the reality is women just don't have the same public advocacy or even family advocacy or friend advocacy in the same way that men tend to. Women advocate for other people. They just do in greater numbers, and they're not always as great at advocating for themselves. And as I'll talk about a little bit later, even with the specific case that I worked on recently, the woman who was exonerated, we exonerated both a man and a woman at the same time. When she got out, she advocated for the man as well, just as strongly as herself. And he was deceased at that point. He died in prison. So certainly, even then, it was the woman advocating for the man. And I think that's something that we have to talk about when we look at why it's so difficult to exonerate women.
Thank you. That's something I had not heard of either. So timely insight from your colleague or your friend. Marissa, did you have anything you wanted to add?
Well, I think what I wanted to add actually kind of bleeds in, Alyssa, to the next question that you wanted to ask. So I'll let you kind of set it up and then I'll take it from there.
Sure. So the next question was for Marissa, obviously. And so the question is, how are wrongful convictions different with female defendants? And how should the concept be thought of differently where exploitation or domestic abuse are involved? And specifically for Marissa, how have you seen this play out, including in your previous role at the Pennsylvania Innocence Project?
Right, and that's exactly, I kind of wanted to pick that up. So it's really not just my experience from the Pennsylvania Innocence Project, but also as a public defender, having represented women at trial. And the themes that both Sunny and Valena, and by the way, Alyssa, thank you for having me as part of this discussion. I'm quite honored to be here with both Valena and Sunny. But that question of self-advocacy and dehumanization at the trial level is so key. And it also picks up with a little bit of what Valena was talking about, that women tend to be involved in crimes because of a relationship with a male other. That could be, as I've represented women who were the carriers of the drugs, who were involved in an aspect of a murder that happened far down the road. And so it's that tie, either because they're drawn in because of battered women syndrome or other issues of coercion from male defendants, that at the trial level is still very misunderstood. So there's an organization called the National Clearinghouse for the Defense of Battered Women, and they provide expert advice for trial lawyers who are representing women accused of violent crimes or others against their abusers. And I would hazard to guess that most lawyers, defense lawyers, don't even know they exist. So if they're faced with that kind of a situation, the ignorance of the available resources to be able to help them through that, and to help them with a narrative and an understanding and a storytelling of their client that could result in a very different outcome. So when we look at those cases of women who are convicted of killing or assaulting their batterer, or who are involved in criminal activity, but because of coercion, those don't fall under the kind of historic wrongful conviction narrative, because they were there, they did it. There was one case that just haunts me still that I actually came across while working at the Pennsylvania Innocence Project, where the woman had been involved with a drug dealer, was at the home, a different male was at her current boyfriend's home, who also was a drug dealer. The two men got into it. They got into a fight in the room next door where she was. She heard what she described as a thick, sickening thud from the room next door. Her boyfriend came in, said, "Go take care of that." She and the other male who was with her went into the room, saw her former boyfriend had been beaten about the head with a weight bar, which was in the room. She didn't know whether he was dead or not. There was a fork nearby. She picked it up. She kind of stabbed him in the leg to make sure that he was dead. He was in fact dead. She wrapped the body in the carpet and then left the room. That was her entire involvement. That's all that came out at trial. The male who actually did the murder testified against her at trial. He took a deal for 3rd degree. He got, I think, a 7.5 to 15-year sentence. She was convicted of 1st-degree murder and is still serving a life sentence for that. So is that a wrongful conviction? Well, yes, in the sense of she certainly should not have been convicted as an accomplice to the murder, but perhaps an abuse of court or something after the fact. But her receipt of a life sentence versus the actual perpetrator getting a 7.5 to 15 is certainly unjust. And so, when we don't really include those discussions a lot when we're talking about wrongful convictions, which is maybe okay, but in terms of defining the injustice for the women, we see those stories much more, that the person who actually committed or came up with the criminal activity does not suffer nearly the amount that the woman who is kind of dragged along into that does. And the other kind of thing that really struck was this issue of dehumanization and self-advocacy. Women are not, as Ms. Knox said in that quote from Valena, are not trained to advocate for themselves. They don't stand up to authority. They don't push back. And so whether it's the lawyer telling them that you have to plead because this is going through, or the officer in the interrogation room is trying to lead them through a discussion to be able to get to a conviction, to a confession, they're more likely to go along with that. But because these crimes are very often against children or others, we have to dehumanize them from the mother role that they have so that the jury is willing to convict them of that. And that's where that dehumanization factor comes in, because we are telling a story at trial. And if the story narrative is that this is a woman who doesn't deserve to have children or should never have had children, and we're dehumanizing her in that process, that gets the jury that much closer to being able to convict. Whereas if the woman is able to go through that trial still cloaked in that a narrative of protective and female role, then it's less likely. But again, it comes back to the trial level for me.
Thank you. Anybody else want to discuss this topic before I ask Sunny about a very specific case?
And I just second what Marissa said about the number of women who, again, they're incarcerated because they're in some way tangentially related to what a man did. And frequently, as she pointed out, they receive a more severe sentence. They don't have the same advocacy or the same attorney who says, hey, listen, let's cut the deal fast. Let's get you that third degree. And then someone else gets the more harsh charge. And you see this in drug cases. But it is a pattern. And I hope that prosecutors become more aware of that, about sometimes a discrepancy between, sadly, often a discrepancy between the severity of the conduct by women and the sentence they receive.
Thank you, Sunny. I promise I'll get to your question, but there's one question in the chat that I wanted to ask, which is, despite improvements in forensics, are the numbers of wrongful convictions or no crime instances still the same? So I guess the idea is a lot of the blame, right, for this scenario that you've laid out, Valena, is on faulty forensics. And I think this person is essentially asking, given that forensics have generally improved, are we at least seeing a decrease in the rate of these types of wrongful convictions, or not, if there's data?
I really see this as something that is in the hands of the prosecutors, because prosecutors can continue to admit faulty forensic evidence. So just to take low-hanging fruit, bite mark evidence, roundly rejected, and yet we still do not have a court nationally that has said, no, we will not allow bite mark evidence into the courtroom. So if the prosecutor brings that evidence, it will probably be accepted and be used. So this is really something that I think turns on prosecutors and their knowledge of forensic evidence, how forensic evidence has changed and developed, which it has. But if there's not that education piece, then faulty evidence can still be used and still get in.
Yeah, can I also speak to that real quickly? Because I agree. I mean, I certainly agree that largely falls in the hands of prosecutors to be more diligent and more scrutinous in what they bring to court. But I would also argue that some of this lies in the hands of the judiciary. We have a major indigent defense problem in our country as far as resources for indigent defense. I'm a former public defender. I'm from an office that greatly respects our public defender's office. But even for appointed counsel, we have a problem of judges not providing funds for proper experts to defend what the forensic experts of the prosecutor's office. And a prosecutor's office is often made up of young attorneys, or to the converse, older attorneys, who maybe aren't fully aware of the impact of what's happening in forensic science. And the only way we get to justice is being able to respond to that and defend that, and proper advice from other experts. But I have seen many cases across my desk where judges have not approved funds for that, but simply said that the defense attorney should be challenging the testimony of the state's witness rather than having their own expert, even just for education. I mean, forget a trial, just to educate themselves on what's happening currently. And I think that is too much of a responsibility to place on prosecutors. I mean, it's a steep learning curve in a multitude of areas, and now we want them to be fire scientists. We want them to be shaken baby experts. Why not provide everyone with the resources to get the best information in front of juries?
Right, and I was prosecutors, we're going to talk about this, I think, later when we're in the discussion. But to highlight that also, I mean, even in forensics, there's still gender stereotypes that come in, right? Like with bite marks, like Valena said, I think we've all reviewed cases where the expert said something along the lines of bite marks that's the tool for lesbians. That's what lesbians do. They bite. And that's insane. But that testimony was allowed to get out, was allowed to go to a jury and allow them to be considering it is crazy. But exactly, Sunny, like you were saying, that failed at every level of gatekeeping. It failed at the prosecutor, who didn't go like, are you kidding? I'm not putting that on there. It failed at the defense counsel, who didn't properly contest that. It failed at the judge, who let it in. Right. So until we have a much better understanding of these forensics, and we're specifically talking about arson, shaken baby syndrome, or abusive head trauma, and potentially bite marks and others, until there's better education, and as long as we let it in, then yes, these things are going to continue. But the data on that is still a ways away.
Thank you. Is there a organization or set of resources that any of you would recommend for prosecutors who would like to fact check the forensics that they're considering using, right? So some of the prosecutors on this call, this might all be old news to them, but I can imagine a lot of prosecutors watching may have considered putting in bite mark evidence themselves, and this is new. And so for those who would like to educate themselves, are there specific websites or organizations that you recommend?
So the Sexual Assault Initiative, the SACI, they do a whole forensics conviction integrity series, which is excellent. They provide the experts as well as how to do them. As well as there are forensics available through Bureau of Justice Administration and Department of Justice that offer terrific resources there for defense counsel and for prosecutors as well. So yes, they are absolutely available.
Perfect. And we'll put that, we have this panel is going to be, it's being recorded, it's going to be put on our website, and we'll include that in our list of resources. So Sunny, getting to the question about a specific case that you handled. So you run one of the handful of conviction review units in the country that has exonerated a female defendant. Can you tell us a little bit about that case briefly, and the ways in which you believe gender shaped both the original miscarriage of justice and then your efforts to correct it?
So try and dial this case down to a Reader's Digest version. It is incredibly nuanced. It was, a case that went back 30 years, but I'll do my best. Essentially, we had a 4-year-old child who was in the care of an aunt in Clarksville, Tennessee. And a lot of reasons she was in the care of that aunt, but she was in the care of that aunt essentially for a summer. Throughout that summer, this child had a variety of very odd behaviors arise, incredibly serious injuries. There was a DCS investigation. There was lying to DCS workers. There were a lot of things that happened in a jurisdiction not ours. At one point, after heated requests from that aunt, another aunt, Joyce Watkins, the exoneree in this case, goes to get the child and take her into her care, really at the request of the aunt in Clarksville. At this point, this child has not seen any doctors for any of these very severe, and when I say severe behaviors, the child was drinking out of the toilet, throwing up regularly at the dinner table, not wanting to get into the bathtub, complaining of pain, withdrawn, just incredibly severe, and got no medical attention whatsoever during this lengthy period of time that she was in Clarksville. Joyce agrees to go get the child. She asks her boyfriend, who is mostly live-in with her, a man named Charlie Dunn, to go with her. They were planning a vacation for the next day, but late at night, they agree, we're going to go get the child. We're going to bring her home. And then on our way to our vacation spot, we will drop her off at her mother's house, who can tend to what's going on. In that very short period of time that they had the child in their care, child's medical issues become more apparent, get worse. Joyce notices blood in the child's underwear. The child just does not seem like the baby that she's always known. And she was very uncomfortable. She contacts the mother that night around 1 a.m. when they get home to Nashville from Clarksville and says, I think something's going on. This is what we've seen. I would like to take her to the hospital. I need insurance information. The child's mother and the grandmother, there's mild dispute to this, but not significant. The child's mother and the grandmother say, wait, don't take her to the doctor. We'll drive up from Georgia and we'll see about her ourselves. We'll be there in the morning. As the night progresses, Joyce is up and down. She's checking on the child. She's not very comfortable with how things are going. Things seem to be progressing in a negative way. That morning, she notices more blood. And the child seems to be less alert and, having labored breathing and things like that. Mother and grandmother have still not shown up. Another aunt who's in Nashville comes over again to check on the child. As the family, everyone was weighing in on this and says, no, I agree. This is not okay. She needs to go to the emergency room. all of this, the boyfriend Charlie has had, other than taking her to go pick up the child and noticing some behaviors himself on the way home, he really has very little contact with his child throughout the night. He's asleep in another room. He's outside working on the car that morning when all this is happening. Joyce picks up the child, puts her in a car, runs to the emergency room by herself. By the time she gets to the emergency room, she has become unconscious. Later that day, she's declared brain dead. She doesn't make it to the next day. This child was in Joyce and Charlie's care for essentially 9 hours, by all accounts, verified by phone records, by where they said they stopped on the way home from Clarksville to Nashville. All of those things match up. Joyce and Charlie subjected themselves to multiple interrogations with police without the benefit of counsel. They never asked for counsel. They consented to searching of their home. And yet experts said these injuries had to have happened within this 24-hour period of time. And that those assessments changed right before trial as well, putting the injuries within 12 hours time, squarely within this time period. 20 minutes before trial, the state's expert changed their opinion, saying that she just noticed something in the file that she had not noticed before. I should note that the medical examiners in this case became famous nationwide for some incredibly disturbing misconduct. And frankly, I would encourage everyone to do a Google search on this and read our CRU report on the case, because it's truly fascinating. But these are disgraced medical examiners. There's just no question about that. A lot of things happened during the trial that I think became, reading back at the transcript, it became very apparent how race, particularly economics, played into this, but also gender. And I've been really trying to think through this week of how to explain how gender played into this, but it really did on a variety of levels, some that are subtle. But first and foremost, there was never an accusation. In fact, there's two sides to this coin, but there was never an accusation or even an inquiry as to whether a woman could have caused the injuries to this child, ever. There were a lot of women who were around this child in weeks prior. But for Fort Campbell investigators, they had eliminated the possibility that men were around this child, which left Charlie being the only man who was around this child. And that became the sole piece of evidence against him, was presence during the time period that they believe these injuries to have happened. Well, what did that mean for Joyce? Joyce was never suspected of causing a single injury to this child. She was never suspected of committing any type of sexual abuse. Joyce became a target of this investigation for two reasons and two reasons only. Her relationship to Charlie, who they believed had done this, and they only believed he did this because he was a man, and her role as caretaker. That was it. That is the entirety of the state's case against Joyce Watkins, who did 27 years for this crime that, by the way, there's not definitive proof happened. There's actually not definitive proof that a crime occurred. Further experts down the road have weighed in and said that maybe some of the sexual abuse that they thought had happened, maybe there weren't good indicators for that. It wasn't clear. Now, do I personally believe in a holistic review that there was abuse here? I do. But do I think that the evidence really weighs that out? I don't. So it is possible that there was no crime here. But for Joyce, solely a caretaker function. Solely her relationship to the person that they thought had committed this crime and nothing else. And no one paid any attention to the fact that Joyce was the only person who actually tried to help this child. The only person who went out of her way to do anything for this child. But it also played in other subtleties in the way the investigation was conducted. One of the primary pieces of evidence that the state brought forth against Joyce was this issue of these sheets in the house. The state made the arguments that Joyce had washed sheets on both beds in the house prior to taking the child to the hospital. Now, certainly if that happened, that would have been suspicious. I mean, it absolutely would have been in the timeline of events. But one thing to note about that is all of the officers, all of them, there were several who recorded these comments in interrogation, did so a year later, a couple of weeks before trial. There was no contemporaneous note taking. There was no recording that captured this so-called admission that she had washed these sheets. But in terms of gender, what I did find interesting is, regardless of what you believe about the sheets, Charlie was living in this house as well, and no one ever asked him about them. No one ever asked him if he had washed the sheets or if he had made any attempt to cover this evidence they thought was covered up. Only Joyce was subjected to that line of questioning, and it became the state's primary piece of evidence against her, this criminalization of laundry. And this was a piece of evidence that they made a huge deal out of may not have even been true. I mean, we actually know it wasn't. We found a report later that was a Brady violation, clearly demonstrating that a DCS worker saw the sheets there unwashed, and the police had taken photographs of the sheets unwashed and saw nothing about them worth collecting. And that's consistent with what Joyce says today. I never told them that I washed the sheets. But my point is, in terms of building evidence, in terms of building a case, only the woman was subjected to a line of questioning related to her role in this household. Only this evidence was used against her. And then, as Valena talked about, the way interrogations are conducted, their impact, and this is subtle. It's not as if I have a smoking gun in this moment, this went this way because she was a woman. But if I put myself in this situation, some of these interrogations became about when Joyce was at her house by herself. And these two detectives who were incredibly aggressive with her would just keep dropping in. And there's a moment that really made an impact on me in terms of how she was treated through this process. She's just getting groceries. And they show up the moment she gets out of her car. There are these two detectives. They're very larger men. They're towering over her. She's a smaller woman, and they are being incredibly aggressive. And she's just saying to them, "Can I please just put my groceries away?" And absolutely not. They treat her horribly. I don't know that a man in that situation would have been so congenial as she continued to try to be. She continued to try to be polite. She continued to try to be cooperative. I have a hard time believing that that would have played out the same way. And then there is the issue of the assumed guilt. And I saw this quite a bit throughout the notes on her interrogation, but also when I talked to her afterwards. We spent some time together at the Innocence Conference in Arizona later this year, and it was the most casual time I'd had to spend with her. But you could see that now that the smoke had cleared, now that she's been exonerated, there is still guilt and sorrow weighing in here. And she was the only person who tried to help this child. So I can absolutely see how maybe when it happened, maybe she didn't advocate for herself as strongly. I mean, this kid was in her care and died while she was in her care, and she never had any opportunity to process any of that. I mean, she was made a suspect really from the moment that the emergency room doctor said these injuries happened immediately. Race also played a role in this, and I know that that's not particularly the topic, but it's difficult to not talk about that in this case. There was incredible dehumanization, not only of Joyce, but also of this child. The way that the prosecutor described some of what happened to this child, this allegation of sexual abuse, he made comments that she was broken into womanhood, and that when someone is broken into womanhood, it doesn't usually lead to their death. This is a 4-year-old. Even in the investigation in Clarksville, there were these notes about interviewing neighbors, because that was one of our questions. Did they interview the neighbors? Because this idea that this 4-year-old wasn't around any other men really struck me. I grew up on military bases. This was a military base. There were men everywhere all the time. So I wanted to know who they interviewed. And they said that they interviewed many people. I do not believe it, because the only statement that he said every single neighbor said about this 4-year-old child who was now dead was that she was a bad kid, but I didn't see any abuse. And I do not believe that. I do not believe that a single neighbor said that about a dead 4-year-old. I don't. I also have trouble believing that they would have said that about a white 4-year-old. I just have trouble believing that. And I realize that that is my own opinion, but it struck me throughout the case, the way this language was used about this 4-year-old child and about Joyce. It was truly dehumanizing from start to finish. And in the final argument, the prosecutor makes this comment of controversy, by the way, in our analysis, but this comment that he was going to introduce the jury to the evil that happens in certain parts of town. And these are 2 Black defendants in the 80s in Nashville, Tennessee, in a predominantly white jury. And I cannot see past the apparent racism in that statement, certainly in its impact on the jury. And I went to this neighborhood, and frankly, it was a very nice neighborhood, and it was a very nice neighborhood even 30 years ago when this happened. So there was no justification for that. But there was an interplay here, I think, of race and gender and how it played out on multiple sides of this coin. But I don't believe that Charlie would have been indicted solely for a caretaking function or solely for presence of this occurring if the tables were turned. I think that Joyce really fell victim to the fact that the investigators believed she was the woman in the situation. She was the caretaker. She was in his presence. So she must have provided this child to him. She must have made an effort to cover this up in some way. And I should also note about this case that Joyce was actually offered a deal early on to turn on Charlie and say that he had done something, a deal that would have time served her. And she adamantly refused. She adamantly continued to advocate for him, even in her interrogations where it was clear they were viewing her as a suspect.
Thank you. That really was the Reader's Digest of the case. I'm sure you had to leave out 5,000 details about the case, but thank you for helping us walk through the intersection, between race and gender, which clearly sounds like you can't ignore the racial part, but then also separating out the gender. I thought, to me, the most striking thing was the line of laundry questioning during her interrogation. There was one question in the chat, I think we've answered it in the Q&A. But Valena, you have written and researched a lot about exonerations of women, but we also know that you have personally been involved in some of these investigations and exonerations. And so wanted to know if there is a case or two that you wanted to share or describe to us involving female defendants.
Sure, and I'll be quick on this because we have so much still left to talk about. But many of these cases, again, are interpersonal cases. Many of them, again, don't have DNA evidence. And so there's fewer innocence organizations that will take the risk on it. It's not going to have that golden ticket DNA evidence that could lead to, maybe easier exoneration. No exonerations are easy. But shaken baby syndrome cases are really very science-based convictions. I would say faulty science-based cases. I have one case again right now, Tasha Shelby in Mississippi, where the elements of shaken baby syndrome were not met. So if you abide by what are the elements for diagnosing abusive head trauma or shaken baby syndrome, not even those were met. And sadly, there's a number of prosecutions that continue to be brought based on shaken baby syndrome and abusive head trauma that don't even meet the standard of the internal standard within that diagnosis. So I want to raise awareness to that, particularly to prosecutors on this call, about how that diagnosis can be precarious, and particularly if there's not even the full diagnosis for it.
Thank you. This next, I'm going to combine a couple questions we had in mind for Marissa, but I wanted to also encourage Valena and Sunny to add their thoughts. And so what can we, this panel is also supposed to talk about what can we do about this. And so from these histories of these cases, what are some ways that wrongful conviction units can look at some of their cases with some of these lessons in mind? And I guess this question might be more for Sunny, but again, I want everyone to be able to chime in, which is how has your work, on the Watkins case, or for Valena and Marissa, the other cases that you've talked about, how have they impacted the way your office prosecutes cases, or would you recommend prosecutors look at their cases? So in short, what can we do about it now that we know how these threads seem to come through these cases, and how can we learn from them, and how can we make our practice as prosecutors better? So we'll start with Marissa, but giving everybody a chance to answer.
Okay, that's kind of trying to think how to dive into that as best. So I think there are a lot of these threads kind of come together, and there's also always, for prosecutors in particular, kind of the dual view. There's looking at cases that we're prosecuting now, and are we prosecuting them using best practices and best scientifically based evidence that we can? That is the most up to date. That, are we still prosecuting cases that involve bad forensics or bad conclusions of a medical doctor or a so-called arson expert? And if we're relying on those, why? And should we continue to rely on those? So those are kind of the going forward issues. And then there's certainly the looking backward issues. So for those who might be unfamiliar, we mentioned CIUs or CRUs, conviction review units. So those are usually specialized units within a prosecutor's office charged with primarily looking at convictions that have occurred in the past and evaluating whether or not they're still valid and whether they were invalid to begin with or have been invalidated by a change in understanding of science or technology, as Valena has been explaining. And then if so, to do an investigation and actively engage to fix that situation, as Sunny has described with those. So it's really looking forward and looking backward at the same time, which obviously is kind of a challenge for prosecutors, but there are ways we think that prosecutors can kind of engage on those, certainly in the looking backward aspect, that is kind of helpful. And let me just kind of, because I'm from the Quattrone Center and we kind of do data all the time, let me just share a little bit of that data that we've been talking about, both Alyssa from you and Valena from yours. So this is the data that we were able to pull from the National Registry of Exonerations, which is probably the nation's leading expert on collecting data regarding wrongful convictions. And that first clump of points is the total number of exonerations involving men, and exonerations involving women. So from this chart, there's about 3,100 exonerations total. Men are represented, they were involved in 2,898 of those, and women in 280. So you can see that right off, women are vastly unrepresented in the number of exonerations. It's about 8%. This second kind of clump is what we've been talking about with the no crime data. So cases where there was no crime, where somebody was convicted of arson, which should have been determined an accidental fire, or shaken baby syndrome, where there was a natural or other cause of death other than shaking the child, which is not medically possible. That's that second clump. So the no crime data, that's about 1,300 exonerations total, so 41% of all exonerations. Men of those were 1,094, 84%, and women were 205. So they're overrepresented in that little clump. But for me, the aha kind of breathtaking moment is when you look at the number of cases of exonerations involving women and how many of those were no crimes. So as I said, women, there were 280 exonerations of women, 205 of those are no crime. That's 73% of all the cases. That's an astonishing number. And that alone should give, I would hope, prosecutors great thought in terms of how are we approaching these cases. So when we're thinking about how do we approach the cases generally, of course, we're looking at things like, how are we doing the reviews of the cases? And I apologize, I can't find the stop share. So if somebody can oh, there it is. Okay, my apologies. So for a traditional conviction integrity unit or conviction review unit, they'll get letters from applicants or on behalf of applicants, as Sunny was saying, kind of focusing on the case. And many times CRUs will take a position, particularly with shaken baby or abusive head trauma, we're not going to look at those. Those are too controversial, or it's too kind of up in the air. But potentially being more flexible in terms of the intake of how you're looking at cases as a broad factor and a potential for no crime, understanding that there's at least a possibility that the science presented at the trial was wrong, either flat out wrong or incorrectly understood. So taking on science cases more generally is one certain reform of that. And particularly regarding women, false confession cases are still not quite understood by a lot of prosecutors doing conviction review units. So taking that confession, putting it off to the side, and then looking at the other evidence, does it point to this woman as a potential or even the likely perpetrator without that confession? And if you're looking at that confession, compare it to the evidence. Does it track? Is it supported by other? And if not, then to take a more broad viewpoint on this case and understanding the gender dynamics involved in an interrogation room, the gender dynamics involved in a prosecution, notwithstanding the woman may have pled guilty or may have been advocating for others, to take that broader viewpoint in terms of looking at these cases. So it takes a different eye than a more typical wrongful conviction case. But if we are really truly dedicated to doing justice, just looking at those numbers shows that we have a long way to go, but there are ways that prosecutors in particular doing conviction integrity work, whether it's through a unit or not, can take a look at those cases in a way that's broader, that would include more women in the process.
Thank you. We're going to ask one more question and then we're going to wrap up the event. But Valena and Sunny, either advice to other prosecutors, running conviction review units on lessons learned, And then Sunny, I suppose for you specifically, are there ways that your office has changed policy or practice, or is thinking about potentially changing policy and practice in anticipation of some of these problems in the future?
So I'll say, first of all, that I feel very lucky to work for an office that has prioritized these issues before I came along. Our office has a policy of open file discovery in every single case. We're incredibly transparent. And beyond that, as policy, we do not contest requests for more testing of scientific evidence ever. If someone has DNA they want us to retest, we will retest it. If there is there are fingerprints to submit or resubmit, we do it. And I believe we're one of very few offices that takes that position, but no one ever has to fight with us over retesting scientific information, evidence ever. As far as what the impact of our unit, frankly, Director of Conviction Review Unit is often off to the side in an office. I have a senior leadership role in my office, and I think that is very important for setting the tone of the priority of this work, both internally and in the community. I have an opportunity to actually impact policy, and I'm very much put out front. My office is very encouraging of doing these kinds of things. And from a systemic standpoint, I spend a lot of time doing panels on what we've learned and talking about cases. And I think that, I have an opportunity to talk to prosecutors and get them engaged in a room in a way that other people don't. Internally, also, we publicly file our reports. Not all offices do that. There are a lot of reasons to do that or not to do that. Right now, we are doing that. And our office members are encouraged to read those reports. And I'm finding that my colleagues are reading those reports. And in doing that, they're getting this insight. And I am being asked questions from young prosecutors. How am I supposed to interpret this forensic evidence? How am I supposed to gatekeep it when I have an expert who comes to me and says, this is what it is? And having those discussions, that's culture change. It is what it is. I have prosecutors coming to me and saying, I think I might have committed a Brady violation. I understand why that can't happen. Can you help me fix it? That is culture change. That is how we get to this place of really prioritizing getting it right instead of getting it done. And I think our offices have a responsibility to do that, but CRU directors have to be out there doing that. They have to be out there talking about what happened in these cases, and we have to be unafraid to talk about what happened in these cases. Again, I feel very lucky. My elected DA gives me broad discretion. Talk about it, tell the truth, be ruthless in telling the truth. That's how we change this. And going forward, I'm scheduled on our calendar to do trainings on preventing wrongful convictions with the cases we've done as illustrations of where things went wrong. And I think that's how we get it done.
Thank you. I love the quote, get it done, or get it right, not get it done. Because I do think, when you're, as a former prosecutor, you get caught up, and I think, and there's so much to do. And so much of it is about getting cases, I hate to say it this way, but getting cases processed. And I think that's how some of these convictions happen. It's not prosecutors who are out to do horrible things to the people whose cases that they're handling, but they're getting caught up in the process and not sort of taking a step back.
One more thing, I'm sorry to interrupt you, but one more thing really quickly, just as a tool for other prosecutors in their office. One thing that I noticed early on when I did my first report is I was quoting things we know about science. For example, eyewitness identifications. And I got tremendous pushback from other lawyers in my office. They've heard it, they've seen it, they know this experts, they know these quotes. It's defense garbage was the comment that was made. So then what I did was go to the DOJ website, and what you find is almost the same information that a lot of these defense experts are presenting, but in a way that prosecutors can accept. Oh, well, if the DOJ said it, well, now this seems more credible. Now this is something to listen to. And so I would like to remind prosecutors looking into this that you can actually find a lot of what defense experts are saying more and more about evolution from the DOJ, from state resources, and you should absolutely look for those.
Thank you. Valena?
Briefly, there's some offices that are having a forensics point person. So there's a lot of trainings on forensic evidence. It's great if the office can do it, but having a point person who specifically as part of their duties is aware of changes in science can be invaluable. So I would encourage that.
Thank you. We have 5 minutes left, and I want to avoid going over. I hope you all are available to stay just a couple minutes late, but I'm going to we had a whole slew of questions left, but I'm going to ask just one because I want to give you all a chance to really answer it. Are all three of you by chance available till say 1:00 or 2:03 if we need to? Okay, great, because I have a feeling this question might take up a little bit of time. So we're all aware of recent efforts to pass criminal laws relating to reproductive rights. Now, this is not intended to be a conversation about abortion law or what is going to happen in light of the fact that Roe v. Wade was overturned. And so putting aside, what everyone on the panel or what our audience members might think about the fact that Roe v. Wade was overturned, I'd love to have a conversation about, what can we learn from these inherently gendered prosecutions, specifically prosecutions related to abortion, from the vantage point of wrongful convictions of women. And so I'll just open up the floor and whoever wants to dive in first.
I'm happy to start off on this. So my book, Manifesting Justice, Wrongly Convicted Women Reclaim Their Rights, does discuss this a bit because there's a danger here that we know of women who have been wrongly convicted of feticide or feticide when they have had a miscarriage. Nearly 1 in 5 women suffer a miscarriage. And one example of someone wrongfully convicted of homicide for what was a miscarriage is Rennie Gibbs, who was a juvenile in Mississippi, and she had a miscarriage, but the state charged her and convicted her of homicide. And there are additionally difficulties with prosecuting feticide. So going back to this ongoing issue, there is unreliable forensic evidence. So one test from the Middle Ages that continues to be used is, if the lungs of this, deceased child or fetus, if the lungs float when they're put in water, then that means that it's a child that had its first breath and had been born. Now that test is from the Middle Ages. It's been debunked. It is not reliable. And yet we saw that used as evidence against Purvi Patel, who was convicted in Indiana. So
sorry, I'm sorry, can I ask when that conviction happened, roughly, if you know the decade?
In the past 5 years. Yes, in the past 5 years, maybe in the past 6 years.
Wow.
And historically, poor women, immigrant women, and even going back to the 1800s, enslaved women were charged with smothering their children. And that was before we knew about SIDS, sudden infant death syndrome. So I just want to bring to mind that there have been these wrongful convictions of feticide and to realize how difficult those charges can be to bring.
Thank you.
One thing that has really struck me about this, and it doesn't matter how you feel about Roe v. Wade, we have an issue. It's arisen in 4 out of 6 of the cases that I've worked on. Whenever you conflate doctors with homicide detectives, it becomes problematic. It just does. I mean, this is how we got to the problems with bite mark evidence and shaken baby syndrome. And, I've seen this in other types of cases, arson cases. When you ask fire investigators to become homicide detectives, well, then the homicide investigation isn't done properly. And a lot of presumptions are made based on what should have been a very specific, very narrow area of expertise. So my concern in this is we are going to be asking doctors to determine if a crime has occurred rather than dealing with a medical issue. And frankly, they're just not equipped, and we're going to have all the same problems again.
Marissa?
All I can do is echo what was just said, with what Sunny just said. I have been just struck by the number of prosecutors with whom I speak about the shaken baby syndrome, abusive head trauma, who say, well, this doctor said it's abuse, so therefore it is. And of course, what does that do but just completely hand over prosecutorial discretion and the duty of the prosecutor to independently evaluate a case to a medical expert. And we're talking about entirely different realms, medicine versus law. And we really can't ever forget that we have, there are discretion aspects here for prosecutors, but of course, legal standards are far different from medical standards, and they should not overlap like that.
Thank you so much. We did manage to answer that question before 2 o'clock. I think that was something that we really wanted to ask, given the timing of this panel. So first, wanted to thank our panelists so much for your time and your expertise. I want to thank the IIP staff for helping put this together, of course. A lot goes on behind the scenes, and we appreciate it. And of course, to our audience, we are only able to do this because of your support. Please email the IIP, the main IIP, if you have any questions, if you have additional things you'd like to ask the panelists that you didn't have a chance to do. I know we didn't get to every single question in the chat, but thank you so much again for this timely and critical conversation, and we will see you soon. Thanks again. All right, bye everybody.
Thank you so much.
Thanks everyone.